Hi, everyone. Thank you so much for joining us and spending about an hour of your morning with us for this presentation. This is Pasadena Humane's virtual estate planning seminar. And I will turn it over to Bill, who's our presenter, in just a few moments. But again, I want to thank you all for being here. And I sincerely hope that you and your loved ones are all staying safe and well at this time. Just a little bit about Bill. Bill is originally from Chicago, and he moved to, oh, I'm sorry, I should introduce myself first. I'm Mia Dunn. I'm Director of Philanthropy for Pasadena Humane. You can tell this is probably the first time I've done something like this. Anyway, at Pasadena Humane, I'm in charge of major gifts and also planned giving. So certainly after this presentation, if you have any further questions or want some more information, you can contact me at any time. My contact information will be up on screen at the end of this presentation, as well as Bill's. So to get back to Bill's introduction, he moved to Chicago as a young boy. He moved from Chicago as a young boy to Los Angeles, where he adopted his first dog named Duke, a brindle boxer. And he is a great animal lover. He graduated from the UCLA School of Law, where he was senior editor of the UCLA Law Review. He has also served as associate editor-in-chief of the National Law Journal. He is a member of UCLA Moot Court Honors Program, and he's also a syndicated newspaper columnist and has also contributed to several books. He runs Hayes Law Firm in South Pasadena, which specializes in estate planning and probate law. Bill also has other talents. He studied stained glass design, I just learned, and also can play flute, and has practiced martial arts for 20 years, attaining his black belt. So he's certainly multi-talented, and we're very happy to have him leading this presentation. So without further ado, I will turn this over to Bill.
Thank you very much, Mia. Thank you for that kind introduction.
Welcome, everybody, to the Pasadena Humane Society's presentation of Your Trust, Your Pet, and Your Legacy, Estate Planning 101. We are going to be obviously talking about how to plan your estate, but there will be an emphasis on how to plan for the care of your pet as a part of your estate planning. And this is a good time to talk about estate planning because these are perilous times in America. There's a lot of uncertainty in our lives, a lot of unease, with all the problems that we're facing. In America, there are 15 million lawsuits filed in our country every year. And that, of course, compounds year after year. We're a rather contentious society. Approximately 1 million families file bankruptcy every year. In the year 2019, the national average for a one-year stay in a nursing home was $102,200. Over 60 million Americans give aid and attendance to family members and friends every year. Countless lawsuits are filed as a result of defective wills and trust. Our courts are crowded. Sometimes it's standing room only. And unfortunately, America has one of the highest divorce rates in the world. We are now number 3. It used to be that I said that we were number 1, but we were overtaken by Belarus and the Maldives Islands. Go figure. And we cannot forget the very real threat of the coronavirus. It is estimated that as many as 400 Americans will be dead by the beginning of the year. This is not anything that we can treat lightly. And because of all of the medical problems that we face, over 66% of all bankruptcies are due to medical bills. It's an astounding impact from people having to go into bankruptcy as a result of medical expenses. And the fact that you have health insurance does not make a big difference because 75% of all of those people who had to file bankruptcy due to medical bills had health insurance, and they still were forced into bankruptcy due to the payment of just the premiums alone or things that were not covered. short statement about who I am. I'm William Hayes, and my office is in South Pasadena. You can see my resume there on the screen. Currently, I write articles for a number of newspapers throughout Southern California on estate planning matters, newspapers like the Inland Empire Business Journal or the Santa Monica Mirror, and a number of other newspapers. I also wrote the estate planning section for the book Wealth is Possible, which is available on Amazon.com. And as you see, we've been cited as a resource on estate planning issues by many of the major media. Our office has been located for the last 22 years in South Pasadena in the historic Behringer Studios building. It's a beautiful old building with a wonderful garden courtyard. I love the building, and I hope that you'll love it as much as I do when you come to visit us. So, as we go through this presentation today, I would ask that you keep an open mind as we take a journey of discovery through what can happen in the life of a person with regard to estate matters. Now, what I ask of you is that you put yourselves in the position of the people who we'll be talking about, because I don't want this to be treated merely as an educational exercise, because that does you no good. You have to understand that these are real life issues, and it's something that you need to plan for. Today we're going to profile a typical couple, Bill and Mary Jones. They have an estate worth about $700,000, which includes their home. Now, even though we're talking about a married couple here, most everything that I say here will apply to you, whether you be single, widowed, or divorced, and you'll be able to easily discern where it does apply to you and where it may not. Bill and Mary have 2 children. There's Susan. Susan is the rock of the family. She is a dependable daughter. Mom and Dad know that they can always depend on Susan when the time comes. And then there's John. Well, John has issues. Everybody has a John somewhere in the extended family. It may be that he has a drug problem, or he lacks incentive, or he's always in and out of lawsuits, or whatever the situation may be. Bill and Mary have all types of planning options. One, they can spend it all. You know, you've all talked to that guy who says, listen, I made this money, those kids can go out and make their own money. Well, that's certainly one way to look at it. You know, I once saw a bumper sticker that I thought summed it up perfectly. It said, no dime left behind. Well, that's certainly a way to look at planning, right? You can also die without doing any planning, and that's called dying intestate. If you plan, you have died testate. If you do not plan, you've died intestate. Many times people will say, you know, I don't think I really want to get into all this estate planning stuff. I don't think it's necessary. And I think I'm just going to put my children's names on my assets so that when I die, everything's taken care of. And when people say that to me, I always give them the same response. I would think long and hard before I did that. And the reason that I say that is because if you put your child's name on your assets, every problem that that child may encounter then becomes a problem for your assets. So if you put your child's name on your financial accounts or whatever other assets you may have, if that child winds up in a divorce or a bankruptcy or a lawsuit or a car accident, whatever may occur in that child's life, even if that child is a responsible person, it now becomes a problem for you. So you've increased, doubled your exposure for your assets. And with regard to real estate, it's particularly a problem because if you put your child's name on your property, what you likely will be doing is creating a major capital gains tax problem for that child. For example, let's say you bought a house in 1980 and you paid $100,000 for that house. And now, in the year 2020, the house is worth $1 million. Well, if you put your child's name on the house and then you die in the year 2020 and the child decides to sell that house, the child will have to pay capital gains tax on all of the appreciation between the $100,000 price at which you bought the house and the $1 million price at which they sell the house. On the other hand, If you were to leave the house to the children in a testamentary fashion, that meaning by will or trust, then they will receive what's called a step up in basis, which means that they receive the house at the $1 million value, and there's no capital gains tax or appreciation to be concerned with. Many times people will say that, you know, my estate is simple. And my response to that is, what do you mean by simple? And generally that means, well, I have a home, I have bank accounts, I have a retirement plan, possibly an insurance policy. And when they say that, I say to them, well, join the majority, because that's what most people have. It may be that assets differ as to the value of those assets. Somebody may have more than one house, but for the most part, we all have the same things. And usually when they're talking about the fact that their estate is simple, they're talking about it in the context of, well, I just want something simple done for my estate planning. Well, simple for many people means just prepare a will and let me be done with this. Well, if you prepare a will, what that requires is that you must go through the probate court process. And what that entails are a lot of complications that you probably really didn't know that you were signing up for. That is not the best way to plan your estate. In the last 30 years of my doing estate planning, I've actually prepared one will, and that was at the beginning of my career. Many times people will say, I can just go get a form, and certainly you can. You can go get a form from Staples. But again, remember, that's a form, and you get what you pay for. A form is something that is one size fits all and has no particular relevance for you and your family and your assets. What I do here in our office is we create something called the Family Wealth Trust that will be much more comprehensive and cover much more for the family and customized for that family's needs. So with our example, Bill has a stroke. Now, what is that going to mean for the family? Well, what that means for Bill certainly is that he's now going to have to face long-term care medical expenses. And that could come in the form of an in-home care stay or adult daycare, assisted living, or stay in a nursing home. Genworth Insurance puts out a survey every year of the annual cost of care in California. And what you see on the screen there are the costs that people have to pay on average, some more, some less, on average for these various types of services. Now, if you have long-term care expenses are not covered by your health insurance. That is why there's something called long-term care insurance. Your health insurance pays for doctor's visits and hospital visits, short stays. It does not pay for chronic, ongoing medical conditions. So if you have a long-term care medical problem, one of the first lines of defense will be your own pocketbook. You have to pay for this out of your own pocketbook. Remember I mentioned that 66% of all bankruptcies are due to medical bills? This is one of the reasons, long-term care medical expenses. If you have long-term care insurance, I applaud you. That's a great thing to have, but not everybody has it. And I know that many insurance companies are starting to not take a lot of people. The number of companies who offer it is starting to decrease. But that is not to say that this is not a good way for you, a good place for you to go, because now what companies are doing is offering a hybrid form of long-term care insurance as opposed to just the standalone long-term care insurance policies. And for many people, of course, long-term care insurance is a problem because they may not qualify for it physically or mentally, or the expense of the long-term care policy may be prohibitive. But if you get one of the hybrid policies, that's a good thing, and there are a lot of benefits to be obtained from such a policy. Medicare is an option for a lot of people, but with regard to long-term care, Medicare will only pay for up to 100 days of care. And after that, folks, you're back on your own again. You have to pay for it personally, and that's a problem, of course. Can you imagine having to pay the expenses of a long-term care health problem, having to pay the hospital bills as well as the medical bills out of your pocket? Obviously, most people can't do that. If you were a veteran and you served at least one day during wartime, then you are entitled to certain benefits through the Veterans Administration. Now, if you don't have a long-term care insurance policy, and you know that Medicare will only pay for a maximum of 100 days, and you were not a veteran who served during wartime, you're really only left with one option, and that's Medicaid, known in the state of California as Medi-Cal. Now, I know that most people think of that as being something for people who don't have things. Well, the dark, dirty secret is that many people who are middle class and upper middle class wind up on Medi-Cal because of the expenses that they had to deal with. They could not support themselves and pay for those bills at the same time, and as a result, they lost their assets and had to start applying for Medi-Cal. In our example, Bill is now disabled as a result of his stroke. This causes many problems for Mary because Bill is unable to handle his own affairs, and she's left with the burden of caring for not only herself and her household, but for Bill. And she needs to know what she can do to pay for these costs that she now has the burden of paying for. How does she do this? So Mary starts looking around at the assets that she and Bill have together. What can I do? What can I liquidate to pay for my husband's care? So one of the first things that Mary may look at is Bill's IRA. Now, she and Bill and Mary for a long time had thought of the IRA as something that was going to be their nest egg, and that they will be able to put their monies into that nest egg over time, and at some point in the future, that was going to support their golden years. Well, sometimes the best laid plans don't work out. So now Mary is faced with the prospect of having to use that IRA. So she goes to the IRA administrator and she says, you know, I need to access the IRA that my husband and I have with you. And she receives a rude awakening, because what the IRA administrator tells Mary is that, you know, Mrs. Jones, I'm very sorry to have to tell you this, but you cannot access this IRA. Obviously, Mary is quite shocked by this. And she says, what do you mean that I can't use this IRA? This is something that my husband and I have put money into for many years, and I know my name is on that IRA. How can I possibly be prevented from gaining access to that IRA? And so what she hears from the administrator is, yes, ma'am, your name is on the IRA, but you're on the IRA as a beneficiary of the IRA. The IRA is actually owned by your husband through his work. That's quite a shock for Mary. So she leaves that IRA administrator fully frustrated as to what she can do. So she starts to look at the next large asset that she and Bill have together, which is the home that they have owned possibly for many years. So the home is now paid for. So she decides to sell the home. It's a large home. The children are no longer there. So she feels, okay, we can downsize. I can use the money to pay for Bill's care, and I'm going to sell it. So she goes to a real estate broker and she says, listen, I want to sell our home. And she gets another rude awakening, because what the real estate broker tells Mary is that, Mrs. Jones, I'm sorry to have to tell you that you really cannot sell your home. And obviously Mary is dumbfounded. How can you tell me that the home that I own I cannot sell? Well, what the real estate broker says to Mary is, Mrs. Jones, the home is owned in the name of both you and your husband. So in order for us to sell the home, we would need the signature of both of you on the listing agreement. Major surprise to Mary, because she's now totally frustrated. And you know, in our office, we become frustrated by this because we see these kinds of problems happen all the time, because we know that there's something that Mary could have done that she did not. So Mary can't sell the largest assets that she has. She's left with one avenue, which is not going to be pleasant. that is called conservatorship. She will have to go to court and get a court order to allow her to take over the legal and financial affairs of her husband. A conservatorship is a proceeding in the Superior Court by which an adult person who is mentally or physically impaired can have someone designated to take over that person's affairs. But it's truly a nightmare, folks. You really don't want to have to find yourself in a conservatorship because it's humiliating. The court is in control of your life. It's time consuming. Your personal information is disclosed to the world. And it's truly very expensive because there are going to be at least 2 attorneys charging against your assets at an hourly rate. And remember, we're talking about something that is long term. So you're going to have all these costs, the attorney's fees and conservative fees and accounting fees. All of this comes out of your assets. And if you're doing this on a long-term basis, I don't have to tell you where that winds up with regard to what assets you have left. Ultimately, Bill dies. And Bill and Mary, when they did their estate plan, they had just a will. Well, if you have a will, that does not avoid the probate court process. In fact, what it does is guarantee that you must go through the probate court proceeding. When you go through the death probate court proceeding, and by the way, I use the word death probate to distinguish it from conservatorship, which we refer to as living probate, because they both occur in the probate court. In death probate, the primary purpose of such a proceeding is to resolve disputes, to pay creditors, to inventory assets, to change title to assets, and ultimately to distribute those assets to the next in line for ownership of the assets. Probate is expensive. You don't do yourself any favors by leaving yourself exposed to probate. If you just are trying to find the least expensive way to handle your estate affairs by having a will, what you really have done is signed on for some very big expenses. One of the larger expenses being the cost of the attorney and whomever his name is, the administrator or executor of the probate estate. So on the screen, for instance, what you see now are what happens with estates of varying gross values. And when the attorneys and the administrators charge for their services in a probate proceeding, their fees are assessed against the gross value of the assets, despite what liens or mortgages there may be in existence. It's based on the gross value, which can mean for many estates that the estate winds up upside down and the heirs wind up not getting anything at all. Probate is expensive, it's time consuming. Minimally, you're going to be probably talking about, especially given today with the coronavirus, minimally 9 months before the estate can be handled. And that's if everything goes perfect, which oftentimes it does not. And I can tell you, I've been the third attorney on one estate that took 28 years. So you never know where you're going to wind up in terms of time. Probates are open to the public. Anyone who wants to know about what you have in your estate and who's going to get it and approximately when only has to go down to the court, to the first floor of the Superior Court, pull the file, and they will know everything about your affairs and who's going to get what. And this is a problem because this is what is used by a lot of scam artists to find people who are vulnerable and in distress as a result of a loss of a loved one. That's why Los Angeles County has often been referred to as the scam capital of the country. Well, it's easy pickings because all they have to do is go down to the court, pull the file, and they can find their next victim. If you have assets outside of the state, that's going to require that you have multiple probates. So if someone left you real estate in Texas, your great aunt left you a piece of property, well, when you die, that asset has to be probated as well. And there will be a separate probate with all the costs and time and exposure that is entailed in Texas as well as in California. So, after Bill's death, let's assume that Mary lives another 10 years. But as a result, she winds up with Alzheimer's, and she has to be placed into a nursing home. That's a problem. But now, because of her experience with Bill's death, Mary had a little greater insight, and before this, she incurred Alzheimer's. She had prepared a power of attorney naming her daughter as her caregiver. Her daughter Susan locates this document amongst Mary's legal papers. She takes that document to an elder law attorney, and she is informed by that elder law attorney that, you know, Susan, we can protect most of your mom's assets if there is language in the power of attorney that gives you specific authority to handle her estate affairs and to move those assets about for the benefit of your mother. Now, that was not the case here, because what Mary did was went, like many people do, let me go find a form power of attorney, and oftentimes such a power of attorney is inadequate with regard to all the things that are necessary to take care of the affairs of that disabled person. And so Susan was unable to do the type of planning that could be done to take care of her mom as well as protect her mother's assets. Most estate plans fail because the documents are canned. Everybody uses a form and thinks that's fine. And that, you know what, I understand that, because they don't know. This is not something that they do for a living. This is something that they have to handle, but it's not something that is at the uppermost uppermost in most people's minds. Estate plans fail because they've done, those plans have done nothing to anticipate the expenses that can come with aging. And that can include nursing home stays and assisted living and adult daycare and all the other things that I mentioned before. Plans fail because people have not properly titled their assets in the name of the trust. If the assets are not titled in the name of the trust has no impact on those assets. Sometimes plans fail because there's no remarriage protection. What happens when a person who has an estate plan dies, but they have remarried? Who do those assets wind up with? Sometimes plans fail because there's insufficient protection for the heirs. So you know your family, you love your family, but you know the faults of the family members, and sometimes you haven't planned well enough to make sure that what you spent your lifetime working for is protected when it is left for your loved ones. And plans fail because people forget that laws change, assets change, relationships change. So there's been no updates of their estate plan. Life is not static. Things will change. And if knowing that they will change, you have to stay on top of your estate plans to make sure that what you planned for in 1990 is still what you want in the year 2020. So there must be a better alternative, and of course I've been alluding to it throughout this presentation, and that is the creation of an estate plan that includes a living trust. An estate plan is a compilation of different documents. There's the trust, which is the centerpiece of an estate plan. It is a document which is amendable or revocable whenever you want to, and there you will name the people who will be in charge of your assets, which we call successor trustees, because you're the initial trustee. They will be in charge of your assets when you are unable to take care of yourself or upon your death. You will talk about who will be your beneficiaries and what conditions there might be for those beneficiaries to receive assets. Accompanying the trust will be something called a pour-over will. A pour-over will is called a pour-over will because if you forget to title an asset in the name of your trust, you can use the will, the pour-over will, to go into court, your representatives can, and say that it was the intention that this asset not go through probate and you want that asset poured over into your trust. Then you will want the powers of attorney. There will be two powers of attorney, one to deal with your financial affairs There you will name somebody who will have the authority to sign your checks and to sign agreements on your behalf when you are unable to do so for yourself. So you want to make sure that someone has the authority to make sure that the utility bills are paid, the mortgage is paid, the rent is paid, when you cannot do so for yourself, because as you know, creditors are notoriously unsympathetic. So we would also want to have a healthcare power of attorney. There you will name the people who will be your representatives in dealings with hospitals and medical providers. And you'll deal with things like organ donation and life extension if you should become vegetative or in a comatose state. Okay, let's give Bill and Mary a quick do-over. Okay, now that Bill's retiring, he has that same dream of starting an exercise program, and you know, he's been talking about it for the last 30 years, and now he means it this time. You're going to plan their vacations, plan their retirement, and consider creating a living trust. You may even look into nursing home planning or how to cover their long-term care medical needs, which will be a possibility for them as they age. So Bill has a stroke. But remember, this time Bill has created a trust. But there's also another truth that should be recognized. Not all estate plans are the same. I mean, estate plans are not commodities like a bag of sugar. You know, if you go to the store and buy a bag of sugar is a bag of sugar is a bag of sugar. It's like buying a Ford at one dealership versus another. But when you buy estate plans, they definitely do not all cover all that you need. When you buy forms, they certainly don't cover those kinds of things. So, this time, because of the type of planning that Bill and Mary have chosen, Mary is now immediately in control of all of the family's assets without the involvement of the court. She'll be able to sell the home. She'll be able to access the IRA. She'll be able to control the financial accounts and the vehicles and all of the other personal property. After Bill dies, Ralph, the next door neighbor. Now, Ralph has had a story that, a challenge that he's had to go through as well. His wife had incurred an illness and died, and now he's a widower. So he may have look across the fence one day and notice that Mary, who is now a widow, she's a pretty attractive lady. And he starts maybe considering asking Mary out on a date. And with the thought perhaps that at some point that they might even get married as time goes on. But the question now presented is this. Mary has assets. She and Bill planned wisely. They have assets, and let's assume that over the time period, those assets have grown. Well, Ralph, on the other hand, Ralph did not plan well. He had to use all of his assets to pay for the care of his wife. And at this point, after having sold his home or taken liens against his home, he is in the position of not having very much at all except his Social Security on which to rely. The question is Ralph seeking to court Mary because he really has a real interest in her, or does he have an interest in the security that her money can bring? Well, if Mary has done the proper planning, that won't be an issue for her, because what she will have done is to create a prenuptial agreement as part of her estate plan. This is important because when Mary and Bill created their estate plan, Bill now dies, well, oftentimes surviving spouses remarry. And if that should be the case for Mary, as it may happen here, you want to make sure that the assets that Bill and Mary created together are not lost to the family, are not lost to John and Susan specifically. Because if Mary were to marry Ralph, the next door neighbor, and then she died, guess where the assets wind up? And guess whose family winds up with those assets? But by having the prenuptial language in your trust, you avoid this issue. Now, again, Mary gets Alzheimer's, but we won't have the same scenario for Mary either, because Mary will have had enough planning in place to make sure that there will be no court proceedings, no loss of control of assets, no delays in having those assets controlled by her family, and there won't be any expenses. There also, because of her Alzheimer's situation, there won't be a need for any conservatorship. Remember that living probate that I mentioned earlier? Because Mary and Bill, when they did their estate plan, had planned for who was going to be named as Mary's caregiver, her legal caregiver with authority over her assets and her person. So they won't have to deal with conservatorship because, again, you never want to find yourself in a conservatorship because it is one of the most humiliating situations. I've sat in court many times and watched people that, you know, I obviously had assets, were vital contributing members of society, and now here they sit with everybody talking around them like they don't matter. It's a horrible situation to watch. And not only that, it destroys people financially. So you want to have a plan that avoids the conservatorship process altogether. Because Bill and Mary have planned, they have a trust. And the purpose of a trust, in addition to so many other things, is to avoid the death probate process. So neither Bill nor Mary's estates will have to go through the death probate process because they have titled all of their assets in the name of their family trust. And remember, death probate is about that, exactly as the name indicates. It's about people dying. And it's important because the assets are titled in the name of that person who has died. But if your assets are titled in the name of your trust, well, your trust never dies. It's an entity. So you may die, but your assets will not. And the type of planning that Bill and Mary did before did nothing to incorporate what I feel to be a very important asset that the family has and that many people overlook. And that is the family story. Most people overlook this, in fact, and that's the tragedy, because it's one thing to leave your property to your heirs, and before long it's, you know, they use those assets and it's gone. But it's quite another for you to overlook the important asset of your family story, your legacy. And when you pass your story on to your heirs, that is something that will keep on giving because it will be a benefit to your children, your grandchildren, your great-grandchildren, to your extended family, and will go on for years and years. That's the gift that keeps on giving and ultimately will be more valuable to the family than the money that you left for them. So when you do a well-prepared estate plan, as we do, that type of plan could have, depending on your needs, various types of subtrust. And so we can do subtrusts that deal with remarriage, the type of issue that I mentioned for Mary and Ralph, or divorce protection for your heirs, so that they don't lose their assets to a son-in-law or daughter-in-law. If they were to divorce, we can set up subtrusts that deal with your retirement assets, or assets that will include your grandchildren, so that they will know that granddad and grandma had thought about them in their planning. You can have subtrusts that deal with guardianship. Let's say you have a biological child, but you are now with a partner, and you want that child to wind up with that partner. So you may want to consider how you do that through your guardianship subtrust. There are special needs subtrusts for people who are disabled and receiving government benefits. You never want assets to go to a special needs person directly, because if it goes directly to that special needs person, the government is going to say, you've got it, you got to pay for your own care with that money. You can create incentive subtrusts for beneficiaries who you know are not living up to their potential, and you set the conditions for their receipt of those benefits as a result of what you leave them. And if you have beneficiaries who are irresponsible, you can create a spendthrift subtrust that the purpose of which is to make sure that though you love that person that you're leaving these assets to, that they don't waste those assets because you know who they are, you love the person, but you know their character. And for those of you who have blended families, you will want to create planning that meets the needs of both of the spouses in the blended family. Now, as I said, not all living trusts are created equal. One of the important sub-trusts that one needs to consider is one that deals with Medicaid planning, or Medi-Cal in California. Remember, that's Medicaid and Medi-Cal are the same thing. But the point of that type of planning is to acknowledge that as we grow older, the government is very clear that most of us will wind up with long-term care health issues. And if you know that, and if you know the number of people who wind up in bankruptcy as a result of that, those health issues, you want to make sure that whatever estate plan you have has Medicaid triggers or language in it to cover those long-term care needs. For many years, our office practiced estate planning, but we did nothing with regard to what happens to those people after they grow old and wind up losing those assets because they didn't plan ahead to deal with Medicaid issues. So we started focusing in the specialized field of elder law, which is a subset of estate planning. And you know, I contend now that if you have an estate plan and you've done nothing to contemplate the problems that can come with aging in the way of medical bills, then you don't really have an effective estate plan. So make sure that your plan includes Medicaid planning language in it. Now, that brings us to the very important subject of pet planning, which is another subtrust that can be a part of your estate planning. Our pets are important to us. You know, I myself had a Cocker Spaniel who I had for 20 years. But in a survey conducted by Kelton Research, it was found that 81% of the people surveyed consider their pets to be true members of their families and equal in status to their children. But on the other side of that, the American Pet Products Association reports that only 9% of people with wills and trusts made any provisions in their trust for their pets. Pet trusts are important because pet trusts are a way for you to make sure that your beloved pet companion is cared for after you're gone. You don't want your pet, your loving pet, to wind up in the streets or in some crowded shelter. You want to make sure that you have a plan in place for that pet to keep that pet safe. If you haven't provided for the care of your pet and you then become disabled or die, who will care for your pet? You haven't planned for the pet. Now, I know that in some vague way, many of us feel, oh, well, certainly my child will take care of the pet or my friend will, but that's making a great assumption. You have to plan for the pet and make arrangements for the pet. Now, when you do pet planning, there are 3 primary documents that you will want to include in that plan. And this can be part of your overall estate plan. But you definitely want to include a provision for the pets to be taken care of through powers of attorney. And remember, powers of attorney are documents that are used while you're alive but disabled. You'll want to have a pour-over will. What a pour-over will is something that is used in conjunction with the trust, so that if you forget to leave something out of the trust, some asset out of the trust, your representative can go into court and have that asset poured over into the trust. And then, of course, there's the trust itself, which is revocable, amendable, but it will cover all of your assets. And that's going to be important for your pet. The powers of attorney are important for the pet because if you become disabled, that is the document that is going to control how your pet is cared for. So you can make sure that you've given authority to someone to access your funds, to sign agreements on your behalf, and to take care of your assets. of which your pet is one. So if you should suffer a disability, you want to provide the people that you are designated as your caregivers for your pet copies of your documents and possibly emergency access to your home. So if your pet is to be relocated out of the state or out of the country, you want to make sure that that person that you're giving authority to for the pet is able to make travel arrangements for the pet as well. Now, your intended pet caregivers will be caring not only for the pet, but they'll be handling the money that is necessary to care for the pet. It's one thing for you to just say, okay, Joe or John is going to take care of my pet. But if you really want to make sure that they're taken care of and taken care of in the way that you would want them taken care of, you're going to have to provide some resources for that purpose. So if you're worried about long-term care disability making you unable to care for your pets, you want to consider naming that caregiver in your power of attorney. Now, there are a couple of ways that you will handle your estate planning, of course, and wills is one of them. And of course, the other way is through a trust, and specifically we're talking about a pet trust. You can provide for your pet's care by either a will or a trust, but you want to create a way to make sure that somebody is named whichever way you choose in those documents. But I can tell you folks that a trust is far better than a will if you are making plans for your pet. One of the major drawbacks in using a will for pet planning is that it can take a long time to execute. If you have a will, you have to go through a probate court proceeding. It is required. Having a will does not avoid probate, it requires probate. And of course, if you go through probate court proceedings, it can take months or even years sometimes to complete the full process. On the other hand, if you have a trust can be implemented immediately. And you can name the caregiver, and your caregiver can access money fairly immediately. And all of the aspects of your trust that you want enacted can be done by the person that you designated as your trustee. And that can be without the delay of a court proceeding. Now, when I talked about powers of attorney, I mentioned that a power of attorney would have control over all of your assets. Well, in the state of California, pets are assets. They are just considered property. I know that sounds terrible, but they are only considered personal property. You cannot make your pet your heir. And so if you can't leave money to your pet, and we've all heard the stories of Leona Hemsley and so forth, but it wasn't as simple as her leaving $20 million directly to her pet. She had to set up an apparatus for the care of that pet, which she did through her trust. And that's what you have to do. You have to set up a method for how the pet is going to be cared for, and you can do that through a trust. You can do it through a will, but remember, it's going to take months before it can be done. So you don't want to leave the care of your pet undetermined. You may want to set up a basic budget to care for the pet that would include how to handle that pet's feeding habits. You'll want to talk about any health issues that the pet has and provide information as to who the veterinarian is who cared for the pet. And if you have medical records, you'll want to make those available as well. You'll want to talk about any conditions that pet has that need to be treated. You can't expect people to just discover these things by chance. You want to make sure that the pet is properly cared for, and you want to be able to tell those people, those caregivers, what the conditions are. And there are other things like that you know that the pet will need mentioned, and that's the pet may have favorite toys or favorite activities. It may have special quirks that you want to be sure that the caregiver is made aware of. If you have a social media account containing photos and stories about your pet, you may want to even give that to the new pet giver. Caregiver, pardon me. Don't assume that someone you know will automatically care for your pet. Your friend may love you, but they may not love your pet as much. So you have to identify the person who really will be a true caregiver for your pet and make sure that they're happy with the opportunity to take care of that pet and to bring that pet into their lives. You don't want to surprise somebody with this. You need to give them proper notice. Now, as I mentioned, you're going to be giving the care of the pet to someone, but you're also going to be giving the money for the care to that person. Now, it's reasonable to believe that some people will, if there are not restrictions placed on how money is given to them, may not use that money fully or if at all for your pet. So you can set up the terms in your trust by which that person has to account for how that pet is being cared for and how the money is being used. And one of the ways that you can do that is by having someone else named to oversee the monies that are used for the pet and the care that is being rendered for that pet. You can name a trust enforcer who will oversee the manner in which your pet is being cared for. And if there is any money remaining in the trust once your pet dies, you can stipulate that the balance is donated to a pet supporting charity such as the Pasadena Humane Society, which has for generations been taking care of pets that are in need in our community. And in my estimation, there's no better charity to give your money to if you have a concern about animals and their care. You should consider the Pasadena Humane Society as a worthy beneficiary of your estate plan. And so you can name them in your trust as one of your beneficiaries. Of course, you're always free to give donations now to the Pasadena Humane Society, but certainly if you are concerned about animals in general and your pet in particular, you will want to provide something for pet supporting organizations in your estate documents. There are 5 primary ways to handle planned giving. 1, you can make a bequest to the Pasadena Humane Society through your estate plan. 2, you can also create what are called gift annuities for the Pasadena Humane Society, and you can set the terms for how monies are distributed to the Humane Society. 3, you might make the Pasadena Humane Society a beneficiary on your insurance policies. I mean, you don't have to necessarily give them all of the money, but you can always, even though you may name your children or someone else as a beneficiary, you can also name the Humane Society as a beneficiary. You can also name the Humane Society as a beneficiary for your retirement accounts. And if you have assets, real property, personal property, those assets may be contributed to the Pasadena Humane Society. And in many ways, you will receive write-offs for having done this type of planned giving. So the thing for you to consider is, when are you going to do your estate plan? If you haven't done one, exactly when do you intend to do it? We are currently in the middle of one of the worst pandemics in history. I guess really in our country, the worst pandemic we've ever had in this country. Now, of course, we had the Spanish flu back in 1917 or 18. But now this pandemic is surpassing the Spanish flu. And if left unchecked, it's going to greatly surpass it. You may want to consider doing some planning, just to be safe. And if you do your planning, I do ask that you support the Pasadena Humane Society. You know, this community will thank you, your pet will thank you, you'll benefit from it, and you'll feel good about it. Thank you very much.
Thank you so much for that presentation, Bill. That was very informative. And to our attendees, I'm so sorry for the audio issues. We did record this presentation, so hopefully the audio can be cleaned up and then we can send out the recording. And so you can take some other time to review the presentation. We are, as you can see right now on your screen, there's a quick poll that we're putting up. And then once that's closed, we will open it up to your questions for about 10 minutes or so. You can put your questions in the chat box. And if we don't get to your question, or if you think of something else after the conclusion of this webinar, you can always contact myself or Bill, and we'd be very happy to answer your questions. And I will also let you know that if you do consider naming Pasadena Humane in your estate plan and will make a gift, people like yourselves will become part of our 1903 Society, which is a group of donors who have included Pasadena Humane as a beneficiary of their will or trust or other vehicle. And they also receive wonderful benefits with that. So if you have any questions on that, you can contact me. So I will open it up right now to questions for Bill.
Okay, the question is, I have a trust already. Can will instructions for pet care be used? How do you get the care instructions into an existing trust? Well, the way that you would get the instructions into an existing trust is to amend the trust. As I mentioned earlier, you can always amend your trust, make whatever changes you want to that trust. So you would just have to find an attorney who will do the amendments to the trust. Okay, the next question. How is the best way to set up funds in the pet trust so that the money is doled out as needed? Well, you would be very specific in the pet trust as to what the monies are going to be used for. So if you have a pet that has special problems, you'll know that monies need to be doled out for medication, for instance, or whatever it may be. You just need to be clear about how the money is going to be used, and the instructions can be put into the trust. And again, if you are concerned about someone doing less than they should be doing as it relates to those instructions, you may want to have a person who can oversee the care of the pet to make sure that those wishes are being carried out. Let's see. Okay. I have thought about getting a living trust and pet sub-trust in the past, but felt the cost might be prohibitive. Well, it's not exactly the, it's certainly not inexpensive, but again, if you're talking about everything that you own, and if you're talking about your pet companion, we're talking about the things that matter most to you in your life. So the question is whether you want to spend the money to do that. Some people never do the. So it's always a subjective thing for each person. Let's see. How is the best way to set up funds in the pet trust so that the money, okay, I got that already. Thank you. If I set up a trust now, pets I have may change over time. Do I have to modify the trust every time I get new pets? Or can I have a general trust, or can I have a general trust to cover whatever animals I have at the time of my death? Yes, you can have a general trust that will cover your pets in general. So, that you can allocate a certain amount of money for the care of the pets. You can set the terms for pets, how you would think pets need to be cared for generally. So yes, you can make sure that even though you don't have a particular pet at this point in life, that you have a plan for that pet in the future. Let's see. Okay. Do separate trusts need to be made for each pet? No, they do not.
you can have a trust set up as a sub-trust under your living trust for all of your pets. And of course, you can name the pets by name, of course, and talk about each pet's needs. Let's see. Can something be stipulated or modified to adjust for what should happen to those funds in the event that one pet survives the other after I've passed? Well, if you've allocated money to take care of a couple of pets, I would assume that there's enough allocation for the surviving pet to take care of that pet. And if the pets are due decease, then of course you can designate how the monies are to be used after they're gone. Okay. What happens if a beneficiary what happens if a charity that is a beneficiary is no longer in existence at the time of your death? Well, generally, with our trust, we will indicate that if the charity that you've designated is no longer in existence, that the monies go to a charity of a similar type. But that's just basic language. But if you have a charity that you are given to and you have concerns that it might not be in existence, then you might want to name other charities that will succeed to that money if that charity is no longer around. Okay, I think that answers all the questions. Oh, how much money should I set aside to have such a plan drawn up? Well, it depends on who you go to, of course, but I've seen trusts go from $500 if you find an ad in a newspaper, because those are just basically forms, up to, I've seen attorneys who charge $6,000. So it depends on who you go to and what you are looking to have completed. Okay. I think that answers all of the questions here. I see that there were some comments about the audio, and I certainly apologize for that. And I hope that that can be cleared up in the recording that is going to be created here. Okay, I think that answers all the questions, Mia.
Oh, thank you so much, Bill. Again, that was very, very informative. And to our participants, once we get the audio cleared up, then we can send out the recording and you can review it at your leisure. Also, following this webinar, we will be sending out a very brief survey to get your impressions of today's presentation, and you'll also have a chance, if there's any questions that you wanted to ask and you didn't get a chance, you'll be able to do it then. And you'll see on your screen right now, there's contact information for myself and Bill. If you would like to contact us, either of us, for more information, we'd be very happy to talk to you. And again, I want to thank you so much for spending part of your morning with us, and just stay safe and be well.
Bye.
Bye, everybody. Thank you very much.